My name's Alexandra Hamilton, and this is the second video in our Legal Guide to Startup video series. I'm going to be speaking with you for 5 or so minutes about shareholders agreements. To help contextualise some of the topics discussed in this video, I will be using our fictional client Gina and her business Streamzer as an example. You may remember Gina and Streamzer from Leah's earlier video in the Startup series, which covered setting up a company. For those of you who haven't seen that earlier video, or who would like a quick refresher, Gina has set up her business Streamzer as a private limited company. Streamzer is an app which reviews our TV and movie preferences and recommends entertainment streaming packages based on those preferences. Gina is currently the sole director and shareholder in Streamzer. However, she has a friend called Han from university who has experience in marketing, and she's thinking about getting him on board with the venture. Gina is thinking about making him a director in the company and issuing him 20% of the shares. Gina is therefore wondering whether she should enter into a shareholders agreement. As Leah mentioned in her earlier video, we would recommend against founders issuing shares to co-founders or employees in the business unless there are clear terms in place documenting the relationship between any shareholders in the company. This is where a shareholders agreement or other written terms come into play. When you're starting out with your new venture, you probably don't want to think about what might happen if there is a dispute between you and your co-founder, or on what might happen if the business became insolvent. Unfortunately, however, disputes do occur. There will inevitably be issues arising throughout the company's life that will need to be navigated by the directors and shareholders of the company. And unless there are clear terms in place, it can be quite difficult to navigate these sorts of issues. Shareholders agreements are also a helpful planning tool, as putting in place a shareholders agreement can help align the minds of the shareholders and directors as to what the purpose and direction of the company should be, and on what the various shareholders' roles in that company will be going forwards. This can help iron out any wrinkles early on and assist the company to run more smoothly going forwards. Shareholders agreements typically set out a framework for how the company should be run and deal with the following sorts of key issues. One key point to understand is that the vast majority of company decisions are made by the board of directors and not by the shareholders. The decisions which are reserved for shareholders are therefore extremely limited. The makeup of the board of directors and how the board makes decisions is accordingly a key term of most shareholders agreements. For instance, using our example of Streamzer, the shareholders agreement might stipulate that both Gina and Han are entitled to be directors, but that Gina, as founder and 80% shareholder, has a casting vote in the event of deadlock. Shareholders agreements can also set out a list of certain important decisions, often referred to as consent rights or reserved matters, which require the consent of a particular individual, such as a founder, or the consent of shareholders holding a given percentage of shares. Using our example of Streamzer again, Gina may wish to protect her position as director and 80% shareholder by ensuring that certain key decisions, i.e. consent rights or reserved matters, require her consent under the shareholders agreement. A shareholders agreement can set out what will happen if a company becomes deadlocked because its co-founders cannot resolve a disagreement. To use Streamzer as an example again, it may be appropriate that Gina and Han agree to take part in mediation in the event of a deadlock. Alternatively, it may be better that Gina is able to buy out Han in the event of a disagreement. A key point to note is that if Gina and Han are in fundamental disagreement, Gina cannot force Han to sell his shares to her unless there is a shareholders agreement or other similar sort of agreement in place dealing specifically with this scenario. It is common for shareholders agreements to stipulate that shareholders must first offer their shares to the other shareholders in the company before they can sell them elsewhere. This is commonly referred to as preemption rights or the right of first refusal. Shareholders agreements will typically contain certain restrictive covenants which seek to prevent any shareholders who leave the company from competing with the business or from poaching its staff or clients. Although it might sound a little morbid, shareholders agreements can also deal with what will happen if a shareholder dies. In the example of Streamzer, Gina probably wouldn't want Hans' shares to pass on to his relatives, who likely have little to no involvement in the company. Leah has already spoken with you in some detail regarding Articles of Association. To recap, Articles of Association are publicly available at Companies House and are automatically binding on any shareholders of the company. Whereas, a shareholders' agreement is a private document between the parties concerned and is typically not required to be filed at Companies House. Ideally, Articles of Association and a shareholders' agreement would be prepared alongside each other, as there are some terms which are more suitable for including in the articles, for example, regarding voting at shareholder and board level, or regarding shareholder tag and drag rights. Whereas, other sorts of issues, for example, confidential investment terms, or personal obligations of the shareholders, i.e. non-compete covenants, for example, are more appropriate to be included in the shareholders' agreement. Having a shareholders' agreement in place can also help demonstrate to potential investors that the company has in place an appropriate corporate structure. This may add credibility when seeking new investment. However, you should bear in mind that investors will typically expect a new shareholders' agreement to be entered into when they take equity in your company. Such a new shareholders' agreement would typically allow them greater levels of control over the decision-making of the company, so as to allow them to better protect their investment. Accordingly, an agreement between co-founders may only be in place for a relatively short amount of time before equity is raised and a new shareholders' agreement is entered into. It is important to think about having clear written terms in place, which may include a shareholders' agreement, before you issue any shares to anyone in the company, whether it be an employee, co-founder, or investor. It is also often easiest to agree at the outset, whilst all the parties are on good terms, what approach would be followed, for example, if there is a disagreement or if the company became insolvent. And it is worth investing in getting this framework right at the beginning so as to help prevent other issues arising further down the line. Our next video will focus on professional advisors and other resources, so please do watch out for that video.